In this country, the prosecutor who helped build the biggest child molestation case in history is now helping the defendants. He says the government made serious mistakes in preparing the case, and now defense lawyers say the whole case should be thrown out of court. Victoria Corderi has this report.
Attorneys for the two remaining defendants in the McMartin Preschool child molestation case are trying to have all charges dismissed. They accuse the district attorney's office of misconduct, and their most potent ally is a former prosecutor who helped put the case together.
These people were wrongfully accused of crimes that really could not be substantiated by the evidence in this case.
Preliminary hearings have dragged on for a year and a half. Last year, charges were dropped against 5 of the 7 defendants for lack of evidence. Stevens charges his former employers with, among other things, withholding evidence. The defense calls it an obstruction of justice.
I'm outraged because I knew way back then that the DA was doing this, but I could never prove it.
The defense thinks the proof is contained in a 40-hour interview the former prosecutor gave to a movie producer who bought the rights to the McMartin story. Stevens is now a paid consultant on the movie being produced by Hollywood screenwriter Abby Mann. Mann turned the tapes over to the defense and to the California Attorney General. He says he's not motivated by publicity.
The movie is years away. It hasn't even been started to be written yet. So it has, the publicity has nothing to do with it. Human lives are at stake.
A judge will decide whether to throw out the case in less than 2 weeks. If not, the trial is set to start November 25th. Victoria Corderi, CBS News, Los Angeles.
Fire crews were called again last night to the site of the former McMartin Preschool in Manhattan Beach. In what is believed to be an arson attempt, the vacant school buildings were set ablaze between 3 and 4 this morning. The fire was brought under control and there were no casualties. Authorities suspect there may be a link with the ongoing child molestation.
How's your step? Second time in 2 months. Should have let it burn.
What a mess. Watch out for the puddle. The windows, look how big they are. You can see right in. We're on the busiest street in town, you can see right in. Anybody could. Do you have curtains? I don't see any. Think they did it? What do you think? Well, when I read Peggy the charges against her, she asked me what a dildo was. The others are the same. Mothers, grandmothers, Christian Scientists. Never as much as a parking ticket. And yet you have these kids saying that they were raped, sodomized, made to do pornography. I don't know. It's kind of hard to imagine it happening here, isn't it? I've seen so much of my time, nothing shocked me. I don't see any closets. Aren't some of the kids saying that Ray would hide them in a closet when their parents came? Isn't that supposed to be in the tapes? Did you get anywhere with those tapes? The other side sees the tapes. Our side flies blind. Doing the best I can. Fucking baby rapers!
hearing in Los Angeles today centered on child molestation charges that attracted national attention. Now prosecutors and defense attorneys are arguing whether the case should even go to trial. And CBS News correspondent Jerry Bowen reports this hearing raises a haunting question. Are the children being lost in the system?
In California, the notorious McMartin Preschool case shrinks from 7 defendants to 2, Ray Bucky and his mother Peggy. Allegations of several hundred children sexually molested are reduced to charges involving 13 youngsters, with the hearing today to drop even those. As the case enters its 3rd year, the cost to taxpayers is well over $4 million, and there's the nagging question, what's gone wrong?
What was wrong, what is wrong, and what we have learned is that the system is not capable of dealing with this crime at all.
In Minnesota, the small farming town of Jordan is forever stigmatized by charges that a score of families is involved in a child sex ring. In the end, only 1 person is convicted. The state attorney general concludes the original investigation is so flawed, the evidence won't stand up in court. The prosecutor is ultimately voted out of office. And there are more hard questions. Can children be believed? Is sex abuse in America really that big a problem?
In the last year, the number of cases has risen dramatically. There's been a 25% increase in confirmed cases over 1 year.
Children are far more competent and capable of telling the truth than our prejudices would have us believe.
These cases can be won. Hundreds of cases are won here in this state every year if they're handled correctly.
Florida, say experts, has become the model for what is correct. The Fooster case, Ileana on trial with her husband Frank.
He was naked.
You are a liar! You are a liar! The child victims were spared the intimidating courtroom atmosphere and allowed to testify on videotape. Just as important, investigators were schooled in the language and memory abilities of the youngsters, a vital step.
You cannot arrive at the truth from a child unless the child understands precisely what they're being asked.
Ultimately, the jury convicted the Foosters in the sexual abuse of 17 children at their babysitting service, and a new standard was set that is slowly being adopted elsewhere.
You have to make sure you don't victimize the witness in the process of the investigation again and then in the court proceeding.
Parents connected to the long McMartin proceedings would argue the standards should have been changed long ago, that other parents following the California case probably think,
the last thing I'm going to do is allow my child to be victimized a second time in a trial. I just wouldn't do it.
And tonight, the McMartin case, now assigned to a second judge, is still without a trial date. Jerry Bowen, CBS News, Los Angeles.
Dropping their children off at the Hickory Tree Preschool in Barnesville. Authorities in Manhattan Beach have raided the Manhattan Ranch.
They're also asking that any parent who has had
the owner of the Greenup School in Northridge has been charged with 16 felony counts of child molestation. Police were called in after allegations.
Sheriff Block said he believed over 1,200 children may have been molested and swapped with children from other schools.
I'm going to ask you, this is about the 1,000th time, for the grand jury transcript and the police report. I mean, if you won't pursue this, we'll conduct our own investigation.
Not while I'm chief of police, you won't. Every minute, somebody's reporting another child molester.
Yeah, there's a good reason for that. You see what happened to Greenup today?
Right and left
yes,
out
did
there.
you hear what happened today?
I'm really not sure how much evidence there is.
There's plenty of evidence. You ever watch the news?
Let's be careful here, or some innocent people will be hurt.
Peggy, I want you to try to calm down.
You
can, okay? No one's going to kill you.
You don't know what it's like here. You don't think anything like this can ever happen to you. I have to go to the infirmary for my medicine, and they have my handcuffs behind my back, and they say words to me. They say they want to hurt me.
I don't know why they put you in general population, all right? We are going to get you moved, I promise.
You seem like a nice man. Who are you?
Dean Gitz is my name. Remember? Judge George called and asked if I wanted to represent you.
How old are you? You look like a kid.
39.
You're much too thin.
In the longest criminal trial ever, not guilty in the California child abuse case. President Bush says a call to cut Social Security taxes is, quote, a charade, and the Soviets call up reserves for Azerbaijan. This is the CBS Evening News. Dan Rather reporting. Good evening. Tears of relief and tears of anguish greeted the verdict today in the nation's longest criminal trial, the McMartin Preschool child molestation case. Jurors heard 124 witnesses and considered 1,000 pieces of evidence in a trial that cost Los Angeles County taxpayers $15 million. John Blackstone reports.
Through more than 2.5 years on trial, Raymond Bucky and his mother, Peggy McMartin Bucky, sat accused of horrendous acts of child abuse. In the end, the jury reached a verdict on 52 charges.
We, the jury, in the above entitled action, find the very defendants not guilty.
13 other counts against Raymond Bucky, the jury could not agree.
And this trial then is declared as to those counts.
A decision on what will happen to those counts will be made in the next few weeks. To many, it is an unsatisfying conclusion to this monumental case. And even jury members say acquittal does not mean children were not sexually molested.
I believe that some of the children in this case may have been molested. I believe that in my heart. But proving it, that it happened at the preschool with these defendants, was kind of shaky.
The case rested almost entirely on the testimony of children who had attended the McMartin Preschool in suburban Los Angeles as long as 10 years ago. Investigators using puppets urged the children to tell stories of incidents of sexual abuse by teachers. The defense insisted the children made up the stories when they were asked leading questions. Jurors concluded the children were unable to tell their own stories.
The children were never allowed to say in their own words what happened to them, and to me that was crucial.
For children who told their stories of abuse during years of investigation, the verdict came as a shock.
I don't understand how so many kids could have that happen and somebody not believe it.
I think it's very unfair to the rest of the world that's been watching this case and the other children that will now be abused because of this.
It doesn't diminish what those kids have lived through and will have to face for the rest of their lives.
During the investigation, Raymond Bucky spent 5 years in jail. His mother spent 2.5 years.
They were never molested, and I'll swear on a Bible, no one ever was ever harmed in our school, ever.
Prosecutors called the outcome a travesty of justice and said laws have to be changed to make sure it doesn't happen again.
The system worked well for them. They were lucky, and I hope to God that none of us ever hear anything in the future about either one of them molesting children.
But others blame the prosecutors.
What the prosecution did was the shotgun technique. They basically alleged far too many counts in the hope that, given all of these accusations, throwing all this mud up on the wall, something would stick, but nothing did.
It's sad, said one member of the jury, because everybody lost something. John Blackstone, CBS News, Los Angeles.
Where did Peggy Ann touch you on your body?
On my dick.
Did you have to touch Peggy Ann?
Yes.
Where?
On her boobs.
Did you have to touch any other part of her body besides her boobs?
Her puss.
Did you see Ray do anything to Peggy Ann?
He would put his dick in her puss.
Did you see Ray do anything to the animals at school?
He would cut the ears off the rabbits.
Did Ray say anything while he was doing that to the rabbits?
He said it would happen to our parents if we told any of our secrets.
Did the teachers take you any other place?
Outside school. To Harry's Market.
What happened with that?
They took us in the storage room and touched us on our dicks and took pictures.
Did you go anyplace else besides the market?
To a church. St. Cross Church.
What happened at the church?
They took us down the aisle, and on the altar they put animals like birds and rabbits and chopped them to pieces.
Who is they, Jonathan?
I saw people wearing black costumes with ropes around their waist. And it would look really scary, and sometimes they have devil suits on.
Devil suits?
Yeah. and we were forced to drink rabbit blood.
The 5-year-old boy gave perhaps the most terrifying testimony so far, as you told me.
Did you hear what he said in there? They'll kill us. Sacrifices in a church.
Just take it easy, Christine.
Glenn, has Ruben been telling Ryan the problems we're having?
I don't know.
Well, she told me she would. I mean, if she doesn't, I will.
Told a wrapped courthouse how he was forced to drink the blood of a slaughtered rabbit.
What did you think of Brian's testimony? Do you think there was actually Satanism practiced at the McMartin School?
Can you believe this shit?
When I
think sacrifices, group sex, people walking around in robes. I mean, next they're going to have some kid telling about the guy they nailed to a cross, or the virgin they sacrificed on the altar. This is getting scary. It's out of control. Don't you think?
Talking about this.
Huh? I mean, don't you think so? I do. I think this is out of control.
To children. I believe we may be dealing with a nationwide conspiracy of child predators who are operating daycare centers as a cover for child abuse.
Satanism, devil worship, is being practiced all across the country.
We have all types of perversion.
Is cannibalism part of the ritual?
The children have spoken about this in almost every instance.
We're made to chew pieces of these children's arms, pieces of their flesh.
When parents begin to realize these things are really happening and not just something out of the dark ages, it'll be much more difficult for these people to pull these things off.
When we hear of ritual sacrifices, our reaction is one of horrific avoidance. We say things like, this only happened in the Middle Ages. It doesn't mean that children are not telling the truth.
A startling new chapter opened today in a controversial criminal trial that's already cost $15 million. The McMartin Preschool child molestation case was considered all but over earlier this month, but that was before public protests, including some 6,000 letters, urged prosecutors not to let the case die. David Dow reports.
Prosecutors met for days before deciding not to close the book on America's longest, costliest criminal proceeding, deciding that Raymond Bucky, the chief defendant in the McMartin Preschool molestation case, should be retried.
It is our present intention to go forward on all 13 counts.
They are the 13 counts left hanging by a deadlocked jury that 2 weeks ago acquitted Bucky and his mother of 52 other charges after a 2.5-year trial.
Everybody, the public, the families involved, everybody is entitled to a resolution in this case.
Bucky had no comment today, but expressed his feelings about a retrial in a weekend interview with Mike Wallace.
I don't want to go through another McMartin trial, but I will, because I know I'm innocent. I'll fight to my last breath.
McMartin parents who insist child molesting was rampant at the preschool were delighted with today's decision.
I'm going to run home and tell my kids. I'm thrilled. I'm overjoyed.
Bucky's attorneys contend the decision not to dismiss the case was driven by PR.
I think it's a combination of pressure and politics, but I think that the jury made the right decision with the acquittal.
In recent days, McMartin parents and child abuse organizations had mounted an aggressive campaign for a retrial. Marches, letter writing, even a lobbying effort before the County Board of Supervisors.
If you believe the children, then you need to do what's right.
Prosecutors say they were not influenced by the demonstrations.
It was our belief that these children were in fact molested at the preschool.
But some legal experts wonder what is to be gained by the retrial.
Why, after $15 million of expense and the longest trial in U.S. history, couldn't this have been done right the first time?
The judge set a tentative date of March 9th for Raymond Bucky's new trial. This one is expected to last at least 3 months. David Dow, CBS News, Los Angeles.
I stood in front of a classroom and taught kids how to perform sex acts.
You're gonna have to talk to me. You're gonna have to tell me everything.
You saw my sister. Who could say that about her?
Ray, you're gonna have to talk to me. You're gonna have to tell me everything, because I'm not gonna stand in front of that court with my dick in my hand waiting for them to throw things at you. Now talk to me.
I said, and I mean, that there will be no surprises. There's nothing.
You know, this is not a frat initiation at San Diego State. There are going to be little children on that stand saying that they were hurt. You have got to be ready for that.
Who could be ready for that?
Hurt by you and your sister.
What do you want me to do? I
grandmother.
Can't make things up.
All right. Why would a guy want to work in a preschool with kids?
I like being with kids.
Never answer that question like that again. Now, Mr. Bucky, please tell the court, why would a grown man want to work with preschool children?
It was my grandmother's school.
Wrong. Come on, Ray, come on.
I could be near the beach.
No, come on. Better, come on.
I dropped out of college and I needed a job.
Better. It sucks, but it's better. You know that some of the parents said that you didn't wear underwear at the preschool. You aware of that?
No, I didn't wear underwear underneath my shorts.
So you got your dick hanging out in front of these
No,
mentions.
they're surfer shorts.
Oh,
they're
your little
long.
surfer dick was hanging out. That makes it
It's
better.
a beach community. I mean, is that a crime now?
No, but it's enough to convict you. That's all. You could do about 500 years in jail. Tell me about your relationships with women, okay? How many women have you been to bed with, Ray? Just round numbers, like 20, 30, 50, whatever.
It's one.
Do you mind? One what?
One woman.
How old are you? What, 25 years old? You've been to bed with one woman?
Only one. Is that another crime?
When you're accused of child molesting, everything is a crime. You're a fruit, right? Come on, you like to bite the pillow, right? Come
No.
on. Hey, we all thought about it at summer camp. Come on, you can
I'm not.
with me. Okay. Got a little gift for you here, Ray. My name is Ray Bucky. I don't talk. I don't listen. Ray, you gotta stop grinding your teeth. Very unattractive in front of a jury.
After 6 years of lurid accusations and interminable court proceedings, the longest, the most expensive criminal trial in U.S. history came to an end 2 weeks ago. A Los Angeles jury in the McMartin Preschool child molestation case acquitted 62-year-old Peggy Bucky and her 31-year-old son Ray on 52 counts of sodomy, rape, oral copulation, and conspiracy. They did, however, deadlock on 13 charges against Raymond Bucky, and he is scheduled to be retried next month. How could things have turned out this way? Why did the jury find so little credible evidence in a case that seemed all but airtight when it exploded in the national press? Well, as we said 3 years ago on this broadcast, there were big problems with the McMartin case, not the least of which were allegations of Satanism and animal mutilations. Now, despite the verdict, it seems no one is satisfied. Not the children who have said they were indeed molested, nor their parents, and not the defendants, Peggy Bucky and her son Ray.
I saw what the system did. I saw how it treated children. I saw how it treated adults. It doesn't work very well. It didn't work for either side. And now everybody, it's a very safe side to be on, saying, gee, these poor children went through hell, and they did go through hell. But I am not the cause of their hell, neither is my mother. Nothing that happened at that preschool is the cause of their hell. The cause of their hell is the product of the adults who took on this case and made it what it is.
How did this case get started? To understand, we have to go back to the summer of 1983, to the mother who made the first complaint about Ray Bucky to the police in the Los Angeles community of Manhattan Beach. She said Bucky had molested her 2.5-year-old son at the McMartin Preschool. And according to the files of the prosecution, she fed the police information about photo sessions involving naked children, trips to faraway places, and bizarre sex acts, stories she attributed to her son. Glenn Stevens was a deputy district attorney in Los Angeles 5 years ago. One of his responsibilities was interviewing that first complaining mother and evaluating her charges. He was surprised with what he found.
She was psychotic when she started the case. She was paranoid. She was schizophrenic. She had delusions. She reported at one point that her house was somebody came into her house and even molested the family dog.
This same mother made phone calls to other parents of children who attended the McMartin school asking if their children had been molested. And the police in Manhattan Beach, they arrested Ray Bucky, but they had to release him for lack of evidence. And then they sent this letter to 200 McMartin families. In it, they named Ray Bucky, and they asked parents to question their own children about possible sexual abuse at the preschool.
That is the letter that started the witch hunt going.
The letter understandably panicked the parents. So the DA sent them and their children here to Children's Institute International, CII, to be interviewed. What you're watching is a demonstration of the CII interview technique using puppets and dolls. And CII's technique produced astonishing results. 85% of the 400 children they saw, they reported, had been molested. And Word of these results quickly wound up on television.
Authorities now believe that at least 60 young children were victimized, and that the ultimate number could well be much greater.
Reporter Wayne Satz of KABC in Los Angeles broke the story in early 1984. And he reported how the children were terrorized into silence.
And terrified because of what was allegedly done to animals in the children's presence. The maiming and killing of rabbits and other animals, often with the warning that such would be the fate of the child's parents if the secrets were not kept.
The local media coverage set off an avalanche of publicity. In the press, magazines, network news broadcasts, as well as on the highly regarded ABC News magazine, 2020.
Up front tonight, the sexual abuse of small children.
How a seemingly harmless nursery school allegedly became a sexual house of horrors.
My God.
It was after the local media explosion in March of 1984 that Ray Bucky, his mother, his sister Peggy Ann, his grandmother, McMartin School founder Virginia McMartin, and these 3 teachers were indicted by a grand jury and arrested on over 300 counts of molestation, rape, sodomy, and conspiracy.
If you can imagine a heavy woman like me dancing around without clothes on in front of children, anything you can think of. I was supposed to put my vagina in a child's vagina. I don't know how you do that, but any dirty, nasty thing you can think of, they accuse me of.
While most of the defendants were eventually released on bail, the series of judges agreed with the DA and refused to grant Ray Bucky bail. Only after 5 years was he finally released on bail last March, one of the longest pretrial detentions in U.S. history. His mother, Peggy, spent almost 2 years in jail.
The inmates threatened to kill me daily.
Because you were a child molester?
Yes, that's what they thought. That's the worst thing you can be in prison, is a child molester. So every day my life was always in danger. I was always handcuffed from behind when I left my cell. And when I would go out into the hall, there were hundreds of inmates waiting to go to breakfast, and I never did know when they might attack me.
Ira Reiner is the district attorney of Los Angeles County.
Why put them in jail?
Mike, what I am not going to do is to rehash the details of the trial. We have a verdict from a jury that we're going to accept.
That's not rehashing the trial, Mr. Reiner. I'm trying to understand the justice system. You put a man in prison for 5 years, his mother for 2 years. What were they going to do if they were out? I'm at a loss to understand why you did it.
Well, first of all, when you say we did it, when I took office, this case was in progress. They were already in jail.
Your office fought any and every effort by the defense to have even a $3 million bail set for Ray Bucky.
Yes.
Why?
Well, look, there was...
Was he going to go out on the street and start molesting children?
At the time, it was felt by the lawyers involved in the case, as well as the judge in the case, that initially bail should not have been set, and when it was set, to have set it very high.
Should he have been in pretrial detention for 5 years? Should his mother have been in pretrial detention for 2 years?
At the time, it was felt that he should have been because of the concern for the kids.
In retrospect, Mr. Reiner.
In retrospect, who can tell in retrospect?
In fact, some of the information the court used to justify holding Ray Bucky without bail was criticized by Ira Reiner 3 years ago on this broadcast. That information came from videotaped interviews of the children done at the Children's Institute. Interviews that Ira Reiner and later the jury in the case described as their #1 problem.
What we had here were the social workers in questioning the children, asking very leading and very suggestive questions of the children. They'd have little Bobby sitting there, and they'd say to Bobby, did the bad teacher touch you in a yucky way in this place right here? And Bobby would say, no. And they would push a few times, and Bobby would continue to say no. Then they'd say, but wait a minute, Johnny has already told us that this happened. Now, you're just as smart as Johnny, aren't you? And after a little bit of this, then maybe Bobby would say, okay, he'd nod his head, yeah, it happened that way. What you have here is a situation then where hundreds of children had been questioned, and then this material is turned over to the district attorney's office. The district attorney then, at that time, without any investigation whatsoever, none at all, turns it over to the grand jury for indictment purposes.
To try to get independent corroboration of the children's testimony, the DA's office, assisted by local police and the FBI, searched for child pornography, for evidence of animal sacrifices, satanic rituals. Then Assistant DA Glenn Stevens reviewed the results.
No Satanism, no photographs, no transportation, no medical evidence with any certainty, no suspects saying, yes, it happened. Millions of dollars were spent on the investigation that yielded nothing to help the prosecution, only helped the defense.
And Stevens says that 4 months after the indictments, there was a startling development. That first child victim, whose mother had started the case, was taken to the hospital. The medical and police reports state that the child whose mother said he was first abused by Ray Bucky was indeed abused again, but not by Ray Bucky, for he was in jail at the time. And Glenn Stevens said that troubled him deeply.
So how can you believe that Ray Bucky is in fact a molester when it's based on hearsay from a psychotic witness?
Eventually, Ray Bucky would stand trial on that mother's allegations. For Glenn Stevens and another member of the McMartin prosecution team, growing doubts about the case led them to leave the case. And Ira Reiner dismissed all charges against 5 of the original 7 defendants. But he decided to prosecute Ray and Peggy Bucky.
We were convinced after reviewing all of the evidence that there was sufficient evidence that the case should be given to a jury for a decision.
Sitting there at that table, when the jury came in, the two of you, what was going through your head? Did you expect guilty or not guilty? Honest.
Not guilty.
I didn't know. You know, I knew the pressures the jury was under. I couldn't believe that they'd buy this whole case, but I knew that they were looking for something. And I just hoped to God that there weren't 12 people who were blind enough to buy into this witch hunt.
We, the jury, in the above entitled action, find the very defendant not guilty of the very crimes.
Right after the verdict, the disappointment of the parents and children was palpable, as was that of Reiner's top prosecutor, Lael Rubin.
They were lucky, and I hope to God that none of us ever hear anything in the future about either one of them molesting children.
The jury, even those who found you absolutely not guilty in 52 counts, say we couldn't prove that Ray Bucky did anything. That's why he went free on those 52 charges. But we are not absolutely persuaded that those youngsters were not molested.
All I can reply to that is I know these children weren't molested at the preschool. In any given number of children, experts would tell you 1 out of, I don't know what it is, child is molested. In some setting, more than likely in the family or incest or something, I don't know. All I know is they weren't molested at the McMartin Preschool.
And you have never, repeat, never done anything of that nature to any child at the McMartin School or elsewhere.
Never in my life.
But despite Ray Bucky's denial and despite the jury verdict, the accusations of the children and their parents continued outside the courtroom. A new public trial began on nearly every television talk show.
Were you molested at the McMartin Preschool?
Yes, I was.
And now many of the accusers were children, like this 18-year-old who never testified at the trial. He had attended the McMartin School when Raymond Bucky was not there.
Is there something wrong with the judicial system that leaves many of the jurors feeling something did happen here that was wrong, but the children were molested, but yet defendants go free?
Groups of kids were taken to various places off the campus of the school.
Another one of the televised accusers was this child, Brian Stafford, who also attended the school when Ray Bucky was not there.
He did not know Ray. Ray wasn't in the school at the time.
He testified in this trial. The jury did not buy one of his stories in this case. He is batting 0.
He is a very persuasive young man.
Very.
Until you listen to his stories. See, that's what's happening now. It's this trial by talk show.
But Ray and Peggy Bucky and the jury decision will never convince these people in Manhattan Beach who marched after the not guilty verdict. They marched, they said, to reaffirm that they believed the children, that they believed the children from several preschools in the area who disclosed how they were abused.
We have 1,400 disclosing children in this community. 1,400 children in this community have been ritualistically abused. 8 schools have been shut down. 1,400 children. I mean, doesn't that hit you?
These people are not quite all on kilter. We're talking, they're believing nationwide conspiracy of ritualistic satanic abuse, pedophiles in preschool settings, and gee, we didn't find one scrap of evidence in a nationwide conspiracy to back that up. That's their belief. Every teacher in Manhattan Beach is a child molester. Every preschool that was ever closed with allegations is a conspiracy of child molesters. You listen to them, and they're talking witch hunt. That's plain and simple. That's what they're talking.
God knows all of us are innocent. And I can't convince other people, but God knows it.
At the end of that march, the parents and children rallied in Manhattan Beach.
And these parents didn't sit through the evidence. These children didn't sit through the evidence. They're a product of this case, that's true. And that system didn't work for them, but it worked worse for the defendants because we can never clear our name.
3 years ago, DA Ira Reiner tried to put the case in perspective for us.
This was a case that involved the molestation of some children. It was blown massively out of proportion to become the case of the century. It is nothing of the sort. It is simply a case of some children, a few children, over a period of years being molested.
Last week, after the verdict, the Los Angeles DA's office was besieged with demands that Ray Bucky be retried on those 13 counts on which the jury had deadlocked, with a majority voting not guilty. Child abuse and advocacy groups gathered on the courthouse steps.
Wake up, America. This is your wake-up call. The system, perhaps, was served, but justice was not. We believe the children because once upon a time, we were the children, and nobody believed us.
After 2 weeks of public outcry, Los Angeles District Attorney Ira Reiner refiled those 13 counts against Ray Bucky.
The decision ultimately, I made the decision.
When we interviewed Bucky last Sunday, we asked for his reaction should Ira Reiner decide to refile those charges.
I don't want to go through another McMartin trial, but I will, because I know I'm innocent. I'll fight to my last breath to get vindicated in the system in some way. Because there's no end to what they've done to me. I can't just put this behind me. So if they want to go with 13 chance, I'll fight them, because I have no other way to go. I'm not going to roll over something I never did.
I like your witnesses. One of them recants, saying he was making it all up so you wouldn't be sad. The other says he went to St. Cross Church and a rabbit was killed on the altar and he had to drink its blood. What are you trying to do, win your case or audition for Saturday Night Live? Why the hell did you use them?
I'll answer that for Glenn, because they're the best witnesses we have.
What about the tapes?
You have to see them to believe them.
What does that mean?
The kids don't have to say anything. Key McFarland and Sandy Krebs tell them everything. If they say they weren't molested, they say, well, everybody else said you were, so you must be wrong. And if they say they were molested, say, boy, you're really amazing.
Well, what did you expect? The kids were just going to come out and say, hey, I was raped and sodomized? Especially after they were threatened with harm to their parents?
Let me ask a silly question. Why am I hearing this for the first time? Didn't anybody look at the evidence a long time ago?
Yes, of course we did, but when we filed the charges, there wasn't time. There was just too much of it. We had to rely on McFarland's logs.
Well, aren't they reliable?
No, they're not.
What exactly do we have going for us?
We have a confession.
Freeman, the guy who was in the cell with Bucky. Do you believe him?
I don't bring forward witnesses I don't believe in.
I don't like snitches, neither do juries.
Well, they might not like them, but they're impressed by them, even if it's only on a subliminal basis.
What about the medical evidence that they were abused?
We can't get any doctor who is independent of CII to corroborate it. No one of stature. They say it's inconclusive.
I want recommendations. Stevens?
Well, there are problems with the case, but there are other considerations too, like the media.
Please leave them out of it.
I'm developing a reasonable doubt on 6. I say drop the charges against the women.
Are you serious? They molested children.
What about Bucky? Can we get a conviction?
Maybe.
Maybe?
He wasn't even at the school when 4 of the children are saying he molested them.
And the kids' stories are changing.
They said that they were taken by the teachers to car washes, to mortuaries, to cemeteries, flown in an airplane to Palm Springs. Not one piece of corroboration. Not one person saw them.
All right, look, this office can do what it wants. As far as I'm concerned, I don't intend to drop any of the charges against any of the defendants. I think we have a clear duty here.
But we're not even sure about Bucky.
Look, here is a guy who abuses drugs, who flunked out of almost every school he ever attended, who sits in this preschool day after day with his genitals exposed to these children. And there's something even more significant.
What?
Let me have a picture, Glenn. This is a picture of Bucky at a pyramid convention. You see this woman here? She told investigators she took him to a motel. The woman even paid the tab, and Bucky couldn't get it up.
What does that have to do with molesting children?
Put it together with the rest of the evidence, Christine. Obviously, this is a man for whom normal sex is not possible. He had to gratify himself some way. Don't you think this begins to add up?
Maybe. But that doesn't explain his mother, his sister, his grandmother.
The old woman in the dark glasses? Look, Glenn, you don't think that women are capable of the same desires and the same aberrations as men?
Philibosian. 208 counts. Do you think he overfired? Could be the election had something to do with it, do you think?
All right. Look, just because we're having some trouble with some evidence, that doesn't make these people suddenly innocent. Children don't lie about this kind of thing. There is a smoking gun out there. I know it. We've just got to find it. Somebody is going to get drunk and confide in someone. Somebody is going to attempt suicide and leave a note. Somebody is going to find those pornographic pictures. That's all we need. One picture. One!
No, it is not reasonably probable, meaning likely. Okay. I think unless there's a problem with it, we should know what the counts are at this point. Okay, can you give me the count numbers?
Count 1, count 2, count 4, count 5, count 6, count 7, count 10, count 11, count 16, and count 41, count 42, count 43, and lastly count 48.
I take it all of you have, as we're shuffling through ours, the new summary of charges. Do all 12 jurors have those? Okay. We're going to be referring to that as we take the verdicts, the 52 that currently exist. Unless counsel would like to be heard at sidebar, I'm prepared to declare a mistrial as to those 13 counts. Okay. A mistrial then is declared as to those counts, and you'll not be asked to further deliberate on the 13. As to the 52 verdicts that you have reached, I think it should be clear that we sealed the verdicts. No one in the courtroom, no one outside the 12 jurors knows what those verdicts were. They were returned to you in a sealed condition, and I understand that you asked for those to reopen them and verify that they were all correct. Have you done that?
Yes.
I've also asked that you deliver them to me in a united form, meaning two forms for each verdict. One would be signed and one would be unsigned. Has that been done?
Yes.
Okay. At this time, if you'll provide those verdict forms for the bailiff, I'll take them and examine them. I want you to understand that my first purpose in doing that is to determine the legal sufficiency of the forms and that we have the correct ones signed and the others unsigned. After I do that, and it will take a few minutes to do it, the clerk then will read the verdicts, and you will be asked to verify that they are your verdicts and go through the count by number and then indicate Since they're charged separately, I don't think it'll be necessary to indicate which defendant is which, but then read the final decision on that.
As to counts 3, count 8, count 9, count 12, count 13, count 14, count 15, count 17, count 18, count 19, count 20, count 21, count 22, count 23, count 24, count 25, count 26, count 27, count 28, count 29, count 30, count 31, count 32, count 33, count 34, count 35, count 36, count 37, count 38, count 39, count 40, count 44, count 45, count 46, count 47, count 49, count 50, count 51, count 52, count 53, count 54, count 55, count 56, count 57, count 58, count 59, count 60, count 61, count 62, count 63, count 64, and count 65. The verdicts read substantially as follows. We, the jury, in the above entitled action, find the very defendants not guilty of the very crimes. Ladies and gentlemen of the jury, is this in fact your verdict? So say you one, so say you all.
Yeah. Would any counsel like to have a polling of the jurors individually? We'll dispense with that then, and at this point it's my duty to discharge you from your service and to thank you for that service. It has been an unusual one. You have served in the longest criminal trial in world history. No jury has had to endure what you have endured. And as a result, I think a lot of the people in the courtroom, the media especially, is going to want to know how you reacted to this case, the criticisms you have and the things that you think went well, if anything. I hope something pleased you as we went along the way for 2 years and 9 months. I have to advise you that you have the right not to speak with anyone about this subject other than being called back to court by a judge. You have the right to say nothing from this point on. If the litigants in the case unfairly, unreasonably try to contact you, you have the right to contact the court, and I will take actions to prevent that. That will be treated as a contempt of court. Beyond that, you should be aware that the news media is going to have a lot of questions for you. You have been the eyes and the ears of the public with regard to the charges in this case. And what you believe, what you have seen, what you have heard is going to be of substantial interest to them. If you decide not to allow interviews, it's going to be very difficult for the public to understand what has been done in this case. Some rationale may need to be advanced. They may want to find out also how you endured for 2 years and 9 months, all of the agonies that we've gone through. Understand that I will stand behind you whichever way you go, but I think that it's important that all of you attempt to talk with the news media if you're willing to do that. We have arranged to have the cameras, if any of you are willing to face them, presented in this courtroom after we take a break, and you can face them by sitting at counsel table, looking out at them and answer their questions on camera. For those of you who do not want to do that but are willing to be interviewed by the news media, we have a courtroom immediately across the hall, and you'll be taken there by back entrances so that you're not going into the public area. No cameras will be allowed, but the news media will be asking questions in that location as well. Could take some substantial period of time, and that's why we've arranged to do it in a courtroom rather than in a hallway. You have the right to say nothing, and if you want to do that when I'm about to dismiss you now, and you don't want to talk with the attorneys either, you can leave the courtroom through the back entrance and we'll escort you out of the building. On your way, you should pick up one of the copies here of the news articles that have been prepared for you. There are 12 copies there, and you can take them now into the jury room if you go there, or if you're going to leave the courthouse, take one with you. Ultimately, you need to tell us whether you also want a copy of the video coverage, the TV news that has been prepared throughout this trial. At this time, there are 15 hours of TV coverage from Newz on 3 different channels in Los Angeles that cover this case. That's going to be 3 video cassettes for you. If you want them, I will produce them for you, and we'll get them to you later on. I need to know how many of you need them, and then order the appropriate number of copies. Beyond that, you can take your notes with you. Those are your property. Everything else that you've had access to should be left behind. If any of you would like to have copies of the transcripts, the reason you can't take them with you now is that they do contain the names of children that are confidential. We will provide for you on your request, and you can give it to us at the same time you indicate whether you want the video coverage of this trial. The District Attorney's Office will provide expurgated copies for you. We'll produce them and have them available for you. That will eliminate the problem of continually exposing the names of the children involved in this case. There's really no way that I can thank you for your service other than to simply say the words. I think a statesman in England said it best. It has never been true that so many have owed so much to so few. You have endured where all else has failed. I don't know how you've been able to do it. I'd be interested to find out from you how you feel about it and what problems have been created so that we might provide better solutions for those problems in the future. At this point, I'm going to ask those of you who are willing to remain to be interviewed either by the attorneys who will join you in the jury room or later by the news media to go into the jury room at this point. Those of you who want to leave can do so. What will happen for those of you who remain is that the attorneys will join you in the jury room for a brief conversation if you care to talk with them about the case. If you don't want to, you can stay in there and stay away from the conversations. You don't want to be in the room at the same time, you can go into my chambers and await the news media conference that will follow later. After the attorneys talk briefly with you, they'll come out and be interviewed here in the courtroom and then go on to their respective locations when you come out to be interviewed by the news media, either in this courtroom in front of the cameras or in the courtroom across the hall off of the cameras. You are obviously, at this point, excused from further jury service. I hope that's a lifetime. All right, resuming with the legal proceedings, it appears to me, if I've counted correctly, and I do appreciate the fact that we did it in block form and saved a lot of people agony, I believe that Mrs. Bucky has been acquitted of all charges.
Yes, Your Honor, that's my count as well. We'd ask that her bond be exonerated.
So ordered.
And that she be discharged.
And she is discharged, and if you care to, Mrs. Bucky, you may leave through the back hallways. You'll be escorted out of the building. You also have a right to face the news media once we take a break, if you'd like to do that here in this courtroom.
May I ask something that's a little unusual, Your Honor?
Yes.
Mrs. Bucky probably doesn't want to see the inside of a courtroom ever again. If you could make a finding as to her indigency or ability to reimburse the county, I think that would conclude her proceedings.
Based on what I know, I would have to make that finding. Is there a contrary request by the people?
No.
So ordered. I do find the defendant does not have the present ability to repay the county for the costs of legal counsel or defense.
Thank you, Your Honor.
All right. As to Mr. Bucky, we have care to, and the spectators, those participants in the case, to be interviewed by the media here.
Is there any need to intone words that Mr. Bucky is discharged of all those counts for which he was acquitted?
There is none, and that is the legal effect of the jury's decision. He has been acquitted on those charges.
Might the court consider a finding of indigency at this time?
We'll do that when we decide what's to be done with the 13 counts. It's premature since the defense in the case has not concluded. Anything else that we need to determine? I do want to thank all of you for your participation and your cooperation with the court throughout the trial. We've had a very difficult time. Anger has been raised many times, and I hope we can all set that beside us and take a good look at the case to see what, if anything, can be changed in the future. The proceedings in this matter are at an end. The counsel may go into the jury room and talk with the jurors. Thank you.
Well, Mrs. McMartin, please be seated.
You told my lawyer that the county will no longer agree to pay him his fee. I have no more money. They took my school. I have nothing left.
Mr. Brunin knew what he was getting into when he took this case, and he's been paid a large sum of money. He will continue on to the end of the hearing.
I've never accepted charity before, and I don't intend to now.
Then I'll get you another attorney.
I won't talk to him.
Mrs. McMartin, do you have any knowledge of the law?
I have something more important. I know the children. I've had them all sit on my lap.
Well,
I think
it is my
all of you
decision,
better
and
take
Mr.
a
Bruno will
course
continue
in
on
children.
as your counsel as to not
I
interfere
will
with the
not,
end of
and I
this
will
hearing.
get up and walk out of this courtroom
Mrs.
if you
McMartin,
insist
you
on
will
it.
remain in the courtroom.
You'll have to stay, ma'am.
Are you going to use force?
Why don't you have a seat?
I will not have a seat. If you wish to use force, do it. You're a little bigger than I am.
You are ordered to sit down or you will be cited for contempt.
Please, Your Honor.
Put me in jail.
Your Honor.
I've been in your jail. I know what terrible places they are.
Mom, you want to go to jail? You wouldn't be able to stand it, and you know it. You do not want to go to jail.
Mrs. McMartin.
Please, Your Honor. I know how you feel, but this is not the way. Don't make things worse for your family, please.
Ma'am?
Working at the McMartin Preschool.
Because I wanted to be a preschool teacher.
And you started teaching there in you started working there in approximately January of '81, is that correct?
Correct.
Prior to January of '81, in the fall of 1980, did you have occasion to be at the preschool in October, November, or December?
I believe so.
And isn't it correct to say that on Mondays and Fridays in the months of October, November, and December, that you were at the preschool?
I believe that's right.
And during 1980, the fall months, what was your role at the preschool on the Mondays and Fridays that you attended?
I believe I mainly observed. I might have helped out, passing out cookies or crackers or something, but it was mainly to observe.
Did you get paid at that time?
No.
Sometime prior to October of 1980, when we were attending the preschool on Mondays and Fridays, did you have any preschool experience in San Diego?
Did you appear on a program in which Wayne Satz announced that 60 children were making allegations against Raymond Bucky before the case had even gone before the grand jury?
I believe I did.
Didn't it concern you that you might be compromising the investigation of the case?
Yes, it did, and I was very upset by it, and I told Mr. Satz so.
You were so upset about it that you moved in with him, is that right?
Objection, Your Honor. Miss McFarland's intimate relations are not an issue in this trial.
Sustained.
Do you think you are qualified to judge whether a child has been molested or not?
Objection. Miss McFarland is not on trial here, even if Mr. Davis would like to put her on trial.
What is Miss Rubin afraid of? Miss McFarland was touted by the DA's office as their expert witness, going around the country giving speeches. What's happened all of a sudden? Are you afraid she won't pass muster?
Objection overruled.
Thank you, Your Honor. Answer the question, please. Do you think you're qualified?
Since I've spent the majority of my professional life devoted to the subject, I think so, yes.
What is your educational background as far as diagnosing children?
I have a master's degree in social work from the University of Maryland.
Did the curriculum include any study in child abuse?
Yes.
Oh. What portion dealt with that?
Well, it's a liberal arts program with psychology, sociology, and those basic courses cover children.
Well, have you ever treated children in the psychiatric sense?
I don't understand what you mean.
You know what psychiatric is. Have you ever heard of that, psychiatric?
Objection. Would you instruct Mr. Davis to stop harassing the witness?
I think if this witness doesn't know what psychiatric means and she has presented herself as an expert, then the court ought to know about that, don't you think?
Objection overruled.
Thank you, Your Honor. Answer the question, please. Have you ever treated children in a psychiatric sense?
No.
How have you treated them?
I've treated them as a social worker.
You worked in Maryland and New Jersey and California, is that right?
Yes.
Were you licensed in New Jersey or Maryland?
Not licensed.
Are you licensed in California?
No.
You are not licensed to work as a therapist or a social worker in any state, are you?
That's correct.
Thank you. Where did you learn these techniques that you use with these children?
From working with families and attending virtually every conference on child abuse in the country. I don't know of any library that's more extensive than my own on the subject.
Permission to approach the witness, Your Honor, and I would like to mark into evidence defense exhibits
KKLL.
KKLL. Your Honor. Thank you. You use dolls like these?
Yes.
Why?
To familiarize the children with their body parts so they're able to talk about it. It's very difficult for them to say the words. Some of them aren't even able to articulate what's happened to them.
How do you know anything happened to them?
I made a determination.
Some of them were in your office only a few minutes before you undressed these dolls. How could you tell?
By the way they were acting, by their not wanting to talk about it.
Did it ever occur to you that they didn't want to talk about it because nothing happened?
Something happened to them, Mr. Davis.
You used different dolls to represent the teachers, did you not?
Yes.
Did you choose black dolls to represent Raymond Bucky, Miss McFarlane?
The children picked the dolls.
Your Honor, I would like to present into evidence sections of the videotape made by Miss McFarlane of the children. Thank you. Thank you.
Under the dresses, they have bloomers. And the little boys have, guess what down here? A real-looking penis. Now, which doll do you think would be good for Ray?
I don't know.
Okay, how about this one? Okay? What I like is their hair, even though it doesn't really look like real hair, does it?
Fuzzy.
Look! He's got a little hair on his great big ugly penis.
Were you trying to teach these children a little bit of racism?
I don't associate the use of dolls of different color with racism.
You weren't trying to make them think that Ray Bucky was a bad man, were you?
I don't perceive a black doll as inherently having a negative characteristic.
How about when you remove the doll's pants and add, oh, he has hair on his great, big, ugly penis?
I commented about all the dolls. I was trying to let them know I was the kind of person they could say anything to.
And who is this?
Miss Peggy.
Miss Peggy. Now, doesn't she have funny-looking boobies? Look at these little hard things that stick out. Have you ever seen boobies with these lines in them? Some of the kids at school told me that her real name is Miss Peggy, because she's kind of fat. Is that true?
Why do you call her Miss Piggy instead of Miss Peggy? What do you mean when you talk about her boobs with lines?
I don't think you understand how frightened these children were. It's an attempt to jog their memories, sort out which teacher was which.
All right, Mr. Monkey, are you going to be stupid or are you going to be smart and help us out here? Because some people think you're stupid, Mr. Monkey.
Well, I'll be smart.
You will?
Mm-hmm.
Okay. Mr. Monkey's a big chicken, and he can't remember any of the naked games, but we think we know a game that Mr. Monkey remembers. It's the Naked Movie Star game. Do you remember that game? Or is your memory too bad?
You told Sam that he was stupid, and that he was a chicken, and that his memory was too bad. Is that right?
I was talking to the puppet.
You don't think little Sam thought you were calling him dumb?
If I believed that, Mr. Davis, I wouldn't have said it.
Now, what the other kids did is they took this doll, Ray, and they started punching him like that. You want to punch him like the other kids did? Go ahead. That's it. Good for you. Good for you. You want to punch him? Go ahead.
Why did you encourage her to beat the doll that was supposed to represent Ray? Don't you think this kind of thing leads the children to believe that he was a bad man?
Not at all. It was therapy. It's best that they let their anger out rather than keeping it bottled up inside of themselves for years. It can become a time bomb if it's repressed.
Sandra Krebs, your assistant, you taught her your technique, did you not?
Yes, I did.
And she was initially employed as your video camera operator, was she not?
You seem to give a great priority to formal education, Mr. Davis.
Miss McFarland, this was, in your words, one of the biggest molestation cases in the history of the world. Why didn't you hire the most experienced person you could get?
Because some of them wouldn't have had the courage to do what had to be done.
What courage was that?
Simply to find out the truth.
Remember all the times your mom asked you if anything happened?
159 times.
I know what we'll do. We tried this with another little girl. Here's Big Bird. Now, what this little girl did was she squeaked once for no and twice for yes. Can you do that? Once for no and twice for yes. Okay. When Jennifer was touched at the school, was it a hand that touched her? No.
No.
Did Ray sometimes do yucky things to some of the kids?
No.
Sometimes people we like can touch kids in places that are uncomfortable and scary. Did you know that Ray did that to some of the kids?
No.
No. We don't want to hear any more no's.
No, 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 no.
You told this child's parents that she was molested, did you not?
We said she was in denial.
Did the parents see all of the tapes?
I beg your pardon?
Did they see all of the tapes, Miss McFarland?
No, we were interviewing 400 children and more were calling all the time.
So all you had to do was press fast forward on the VCR, and you had at your fingertips each child saying whether or not he or she had been molested. Is that correct?
You give me too much credit, Mr. Davis. The very idea that after an hour or two with me, a child would say he was molested even if he wasn't, makes me out to be some sort of genius.
Children between 3 and 6 can be very easily tricked. They are at this developmental stage of magical thinking. It is very easy to intimidate them. You did make that statement, didn't you, Miss McFarland?
I knew what would happen when I put myself on the line with these tapes. I knew people like you would pick apart every word, every inflection, but somebody had to do it, Mr. Davis, so the children could tell the truth.
The truth. Was what you got the truth?
What are you trying to suggest? I would deliberately plant false ideas in their heads? Is that why you think I entered into all of this?
No, I think that you entered into all of this for a very noble reason. To help children that you honestly thought had been traumatized, and maybe spare them going through another trauma in this very courtroom. But I also believe that you must have known what a dangerous technique this was. Highly suggestive. A technique that was meant to be used where abuse was already an established fact. And yet in this case, there was no such evidence that abuse had occurred. And you went ahead and used this technique anyway. And this technique became the evidence.
That's ridiculous. Of course there was abuse. The children told me, I heard them, and you and the entire justice system are trying to stop them from telling the truth.
Well, I don't blame you for not wanting to face reality, Miss McFarland, because the reality is this. You didn't listen to these children. You closed your ears to the truth that they were so desperately trying to tell you. And you ended up implanting instead in their fertile imaginations a memory of something that never happened.
Why would I do that?
Well, I don't know why, Miss McFarland. I do know that Mr. Satz came along, didn't he? And then you suddenly became the Joan of Arc of the children's movement.
Your Honor.
You were the champion of children's rights, their savior.
Mr. Davis.
Maybe it all went to your head. Maybe the power trip was too much to resist.
Your Honor.
What power trip?
A halo around your head on Oprah every afternoon at 3. You were on a roll, weren't you? Did it
Your
feel
Honor,
fabulous?
objection.
Did it feel just
Mr. Davis.
great?
That's enough. Objection sustained.
Thank you, Your Honor. I have no more questions.
My stomach just hollowed out. I was shocked. I was beyond tears. I just didn't think it could happen.
It wasn't what you expected?
No, I don't think, those words will stick with me probably the rest of my life. I will not forget, those 2 words.
I was pretty shocked also. I had assumed that, we had all done our best. I can sympathize with the jury and understand where they were coming from. But I really expected yeah, of course I see it from my point of view, but I had really expected a guilty verdict, and I was pretty upset. Yeah, I think we all were. You all got together this afternoon.
Hold it. Wait, I think there were others who wanted to answer that question.
That's okay. No.
Anybody else who wants to answer that?
No.
When you're talking, just get as close to the mic as you can. I know it's hard, but that's how we're all picking up your sounds.
Okay.
Anybody else who wants to respond to that particular question?
Okay, I felt kind of helpless. It was like really the only thing I could do was just sit there. And that was it. That was the end of the 6 years. That we had went through like such, I don't know, pain.
You feel a lot of pain?
Mm-hmm. But it's over now. It is. Try to go on with my life because I'm still.
We will. I don't think we have to try. I think we will.
Yeah. Well, excuse me. Yeah, we will.
I was really disappointed because when something like that happens to us and then they get to go free, I just couldn't believe it when they said not guilty. But that's the way it goes.
I couldn't believe that they said that 6 years. They said not guilty in like 1 minute, and that was just it. I mean, it went that fast. I couldn't believe it.
Go ahead.
I was truly shocked to hear the not guilty verdict. I mean, just after experiencing what we went through and what our parents and everybody tried to do in the last 6 years, just they're free now, and it just was such a shock to hear that they were gonna go free, and terrified.
Do you feel like, what do you think went wrong?
Is that directed to anyone?
That's not a question. What went wrong with what?
With what? Yeah.
Why do you think this verdict is the verdict that came down today?
Is that directed to anyone?
They told us.
Guys, raise your hand when you want to answer the question, and you can talk as long as you like, and then the next guy will get to answer the same question.
The jury told us that they reached that decision because they had no real. They were not proven guilty. They said on the news that they believed the children, but they just did not. They weren't proven guilty.
Yeah, with evidence. I think they had a shadow of a doubt, which held them back from giving the guilty verdict, and that was hard for all of us because, of course, as just the children, we can see no interference at all from our side, but of course from theirs, they have to put away from their minds, this fact and this fact, and just get straight to the point. And if they can't be 99% sure, then they cannot give a guilty verdict. And it was just that we were so sure of ourselves, and we still are, but it's really hard, just to accept the fact that we weren't able to prove in a court of law our point. I mean, although we still know what happened and we believe in ourselves, the fact that they will not go to jail over something so trivial to us as messing up or having something go wrong in the court of law was really hard to take. And I would consider that to be the main problem, was just that maybe things didn't go right for us just in the court of law, and that really kind of messed it up, and that was hard. That was really hard to accept.
I think if we were to go again, now that we're older, it was a couple years ago. I mean, our memories would, it'd be a little bit, we wouldn't have as strong as a memory, but we'd still be able to remember, what has happened to us. It's just too great of a thing to forget. And now, I think with our, we'd be able to take everything more seriously now, and, really, get down to the point. I think we were so scared, it was a couple years ago, and I've really changed a lot since then. And I think I'd just be really, I'd do a lot better now, with more insight on the whole thing and more experience.
The jury said that we made up those stories, and some of them weren't true, but I don't know, something like that happened to us. You really, and that we could have forgot about it. We were kids and everything. We didn't know what was happening. But when something like that happens to us, it's kind of big, really big in our life.
Hard to lie about too. I mean, we're not. It's just,
Well, I think like now that we're older, I think we could deal with it more and like to deal with it in like a more mature way. I'm like, even though it still hurts, I still think we can like deal with it. I mean, pretty well and still stand our ground.
Anybody back here want to answer that question? And the question was, what do you think went wrong with the legal system to reach this result?
Can you come to the microphone? Please do help us out, please.
I think that the case shouldn't have lasted that long because I don't know, being on the jury for for that long would just, I don't know. I don't think it should have lasted that long.
I can see how it would easily confuse somebody and cloud their minds with all the information that they received. You know, of course, seeing it from our point, we'd see it as something easy, you know, something clear-cut and, you know, real simple decision. But they had, and I can understand that they had a lot of information that they had to deal with, and I could understand it being very hard for them.
I'd like to ask, especially for the three who testified in court.
There's now four. We've just been joined by a fourth.
Who also testified in court. One of the jurors said that he felt that the kids were not really being able to tell their story in court. That was because of the, they didn't use the word coaching, but because of the interview techniques, etc. They weren't really hearing from the children when you all testified in court.
Let's do it this way. We'll start at this end of the table and come across and then go through the back so that we can put some order.
Well, I think the thing to remember is, you know, when we went to the Children's Institute, we were, I think, I don't know how old I was, but I was not really, I was just starting in life, and, we were scared because, we were threatened at the school, and that had a great effect on, our testimony and everything. Just being threatened, it still scares me to think, of, actually being threatened, having my parents' lives threatened in mine.